Meeting to order. This is a special council meeting of the Village of Krause governing body to hear an appeal. Please turn your phones off, set them on vibrate, whatever, and then please stand and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. So I guess first thing out of the chute, I need approval of the agenda, please.
So moved.
Second.
Okay, I have a motion to approve the agenda. Second, any,
You want to have attendance? Roll call, who's here?
did I not do roll call? Oh, I'm reading it. I'm, okay. Counselor Murray,
Yes.
Counselor Burkett,
Yes.
Counselor Alsobrook,
Here.
Counselor Knight,
Here.
Counselor Woolman.
Here.
Counselor Miera.
Here.
Okay, we got everybody. So we, is there any comment on the agenda? Any question? Okay, all those in favor signify by saying aye, and we'll move on with the
Aye.
agenda.
Aye.
All right, thank you. What we're discussing tonight is appeal of variance 24-03. I'm going to go through a little script here because this is going to be recorded and we want to have a clean recording. This is a special meeting of the Village Council, which is a hearing for the appeal to the governing body of a variance to lot size request, variance 24-03. This is an appeal of the variance to lot size granted on May 15th, 2024 to applicant Steve Gutierrez. The approval granted the applicant the ability to subdivide a 2.93 acre parcel into 3 lots. The appellant is the village administrator, Ron Curry, who is appealing on behalf of the village on the grounds that this variance violates section 18-33 of the village code requiring a minimum lot size of 1 acre. The appellee is original applicant Steve Gutierrez. I'm Jim Fahey, mayor of the Village of Krause, and I'll be functioning as a presiding officer of this hearing. The hearing today is a quasi judicial hearing and the decision will be made by the members of the governing body. Once again, we'll do the roll call for the record of the recording. Counselor Miera. Did you step away? What did he say? Counselor Miera, are you there?
You hear me?
Yes.
Yes.
Counselor Woolman,
Here.
Counselor Knight,
Here.
Counselor Alsobrook,
Here.
Counselor Burkett,
Here.
Counselor Murray.
Here.
Now I'm going to ask the appellant to please identify himself. And Mr. Curry is raising his hand and the appellee to identify himself. And Mr. Gutierrez is raising his hand. Thank you. The scope of this appeal will be limited to whether the council will uphold the decision of the Planning and Zoning Department to grant the variance 24-03. If the people go outside of that scope, I'll call you on it and I will say that it's irrelevant. And that goes for the parties as well as the councilors unless it is really related to the appeal. We're recording this meeting tonight so that a complete record can be created of everything said. However, please remember that we cannot create an accurate record when people are talking over one another. So I'm going to be strict about people talking over one another. If people start to interrupt or speak while others are speaking, I will stop them so we can get a clean record. I would also remind all parties to please speak into their microphones so that their comments will be picked up on the recording. Also, please no conversations in the audience. If you need to have a conversation, please go out into the foyer. You can hear what is going on in this council chambers out there. The council will have the opportunity to ask questions. Council, if you have any questions, please make sure you preamble with mayor so that I can make sure that I see you, recognize you for the record and let you speak. Again, that is for the record so that we get those questions and answers down. The question should be focused on clarifying the record or the argument given and should not include new information or new evidence being offered by a counselor through asking the questions. I'm also going to assume that everyone's demeanor is going to be appropriate and there will not be any badgering or argumentation of witnesses. I will call people on that. Evidence in this hearing is made up of everything in the record from Planning and Zoning Commission hearing. New evidence or testimony will not be allowed unless it is allowed by the governing body to be introduced here for the first time. The decision is on the record of the hearing below, and if an exception is granted by the governing body for good cause, that new evidence will be entered. Evidence includes testimony and exhibits. If either party has exhibits to present that are not in the packet, please present them to the village clerk, Melanie Romero, for distribution to the governing body or for display on the video screen after it is determined admissible by the governing body. Before I give an outline of the specific process for this hearing, here's a general outline of how the hearing will run. First, we'll hear testimony from the appellant as to why the decision of the Planning and Zoning Commission should be reversed. Second will be the presentation by the appellee. Each party's time will be limited to 15 minutes. You may request additional time if your presentation is complicated and upon request, and if the governing body agrees. The appellant and appellee may present arguments or call witnesses if allowed, again, by the governing body, and any new witnesses will be sworn in by the village clerk. Both parties can rely on the record of exhibits and witnesses from Planning and Zoning Commission meeting where the variance was heard. If there are exhibits or visual arguments, these again should be given to Melanie Romero to put on the screen. You will need to explain what the exhibit is. Before making a final decision, counselors or I may have questions of the witnesses limited to clarifying the evidence, the parties' arguments, or the decision of the Planning and Zoning Commission. No independent evidence should be offered by counselors or me, and I will remind us all if necessary. After questions, I will close the hearing and the governing body will deliberate. The village council may make a determination in open session or decide to deliberate in closed session as allowed by the Open Meeting Act. All decisions must be made in public. The governing body may grant the appeal and deny granting the request variance, deny the appeal and uphold the variance approval, or amend the decision of the Planning and Zoning Commission. Once the decision is made, then there will be a direction to our attorney to prepare a written decision and findings of fact and conclusions of law supporting the governing body's decision based on the facts established in the record. The hearing date shall be set at that time for a vote on the form of decision as soon as practicable. After the approval of the final decision, the appeal will be concluded. Any questions? Any questions? Okay. All right. First up, Mr. Curry. Please state your name and where you live.
My name is Ron Curry. I live at 7 Manzano Road, Corrales, New Mexico.
Thank you.
Thank you, Mayor, members of the governing body. I will be speaking tonight briefly on a short presentation and then be followed up with Lori Stout, who will also be making a presentation to fill in some of the facts. I guess my two main asks tonight would be that the ordinance be upheld and that you, as the council, which is the final planning and zoning authority, reverse the Planning and Zoning Commission on this particular appeal. One of the things that I would like to bring up, and you can see this in the letter that was written on the appeal, is that Village Code Section 1833 governing A1 agricultural and rural residential zones requires the following. B, 1 dwelling unit per lot. Maximum density shall be limited to 1 dwelling unit per net acre. The minimum area of each lot shall be 43,560 square feet or exactly 1 acre. The section of the code governing variances is 18-48C4. There are 4 main items that are listed in there. A is the variation of this article will not be contrary to public interest. The variation will not adversely affect adjacent property owners or residents. C, the conditions are unique to the property and the variance is authorized only for lot controls and not for use on the premises. I'd just like to point out that in the initial discussion in front of the Planning and Zoning Commission, it was item C, the conditions are unique to the property. The argument was made that there was historical connection, which made it unique. You will find no such reference in our ordinances that there can be a reference to historical properties regarding a unique property. It does not exist. Lori, when she speaks here shortly, will fill in some of the details on that. And she will also likely, depending on how the discussion goes, will introduce some more evidence. With that, Lori, would like you to come up and continue.
Thank you, Administrator Curry, counselors. As Administrator Curry mentioned, this was a variance to lot size. And what we are focusing on is one of the conditions for that to be granted, and that's that conditions are unique to the property. So that night in front of the Planning and Zoning Commission, the applicant's argument was that this land had been in his family for a very, very long time. That was his first point. And I'd like to read 7 lines from the minutes that are in your packet. It's lines 136 through 142. And this is Mr. Gutierrez's direct testimony. Third condition of a variance is uniqueness of this property. The major difference is when most families come into Corrales, they are purchasing land and know the land that they're purchasing. They know the size and conditions. For historical families, the lands are transferred to us. Over time, those lands are impacted by various conditions that happen. For instance, when I was doing the Tierra de Corrales subdivision, my grandmother had to submit deeds to us in order to replat. Those deeds came from the 1700s. They were in Spanish and the measurements were in Vargas. This whole area of land has been around for a very long time in our family. And one other line, these lands have existed well before any rules came up in the village. We've been impacted by that because we've lost land. So I would like to request the council's permission to enter into evidence a deed that was not shown to Planning and Zoning Commission because I did not have it. I got curious after this happened and I went to the county and did some research. So I would like to introduce a deed with permission that may refute at least that point and the other point that I'm going to make.
Do I have a motion to approve the deed?
So moved.
Do I have a second?
Second.
Okay, any questions? John, you were getting ready to ask a question. Okay. If there are no questions, all those in favor signify by saying aye.
Aye.
Counselor Mira,
Aye.
thank you. All right, go ahead, Lori.
Thank you.
Oh, yeah, Millie.
Wait till they can see it.
Thank you.
So what I'd like to point out is for this subject piece of land, in 1966, Mr. Gutierrez's parents purchased it from Louis DeBoot, a single man. They believed they were purchasing 2.58 acres. And right there on the front page, it says it's bounded by Antonio Garcia's land, Corrales Road, Julio Tenorio, and the Conservancy Main Canal. So 2.58 acres. However, the discussion in the Planning and Zoning Commission turns out there had been a plat by his parents that they did in 1999, and they in fact have 2.93 acres. So his second argument to uniqueness was that the MRGCD Main Canal and Corrales Road paving had reduced the size of the land. But that did not happen. But that's what the Planning and Zoning Commission heard. They heard the historical aspect, and they heard that various government agencies had reduced the land, and it pulled at their heartstrings, and they ruled as they did for that reason. There are currently 2 tracts in this subdivision. His parents subdivided into 2 tracts. There's 2.93 acres. And there are currently 2 houses on one house on each lot. So I would also request respectfully that the council reverse this decision. We have things in our code having to do with historic preservation of structures. There's a historic incentive. If you restore a property, you can actually get fees reduced for various applications. We have a historic zone but we simply don't have anything in our code that allows a historic exemption for a lot size. And in my summary, I had said that I feared it would open a can of worms. And I can tell you that people have been coming into the office and are very interested in the outcome. And that's my testimony unless you have any questions.
So
Thank
any
you.
questions? Counselor Knight,
So,
speak into the microphone, please.
Oh, thank you, Mayor. So when you gave us this warranty deed, it said track 8 being 2.58 acres. Now, is that what we're talking about right now? Or are we talking about 2.93 acres?
In fact, when that piece of land that they thought was 2.58 acres, when they purchased it, when it got platted in 1999, it was found to actually be 2.93 acres. It was not reduced by the action of the village or MRGCD or Corrales Road. In fact, they had more land than they thought at purchase.
Okay, thank you.
Counselor Wallman.
Thank you. When you talk about the 2.93 acres, and it divided is, but it's short of the, obviously of the 3 acres. There was some discussion, and I don't know what's appropriate now, but there's some discussion about land across the street. And I'm curious about how that works. Could you kind of explain, to bring it up?
Absolutely. If you're familiar with Sandia View that has an 8-plex on it, it's not sitting on 8 acres, but in order for that to happen, in their plat, it is designated some separate land that is set aside. And that was one of the options discussed during P and Z. And I also know that a property owner to the north who has about 5.17 acres, at least at the time, was willing to sell a smidgen of that and still retain his right to have 5 lots.
I have a follow-up question. So across Corrales Road, there's a parcel of land which they
Counselor
own.
Wallman, can you speak in the microphone,
sorry.
please?
Across Corrales Road, there's a parcel of land which they own, which to combine would be at least 3 acres. How close, but still separated, does land need to be included? In other words, if they own a piece of land at the southern end of the village, would that be considered?
That's a good question. The
It's
only,
a density question.
yeah, the only thing I can bring up as the example is Sandia View subdivision. There's actually a lot in between the 8-plex and the set aside land. And that's the example I'm aware of. So I really don't know. I think it should be adjacent because it's going to be on the same plat. It should be close.
Would Corrales Road running through the center of it still make it adjacent?
Yes.
It would. Okay, thank you.
Any other questions?
I do have a question about the finding of the Planning and Zoning Commission, which it's a bit separated, but one commissioner stated that there should be a survey. If they were to approve, there should be a survey. Number one, was there a survey actually done in 1999 as
Yes.
part of the plat?
Yes.
And secondly, has a survey, as far as you know, been done as a result of the ruling of the Planning and Zoning Commission within the last 60 days?
Not to my knowledge, the applicant might be able to answer that question.
Good. Thank you.
So is this the council meeting or is this a hearing that you're watching?
Is someone online speaking?
I think they muted themselves.
I think they muted themselves. Everyone's muted now, so I think somebody was speaking online, but looks
Oh,
like they
okay.
muted themselves.
Okay, Mr.
I
Gutierrez.
apologize. It was my house, my family, so I apologize for the interruption.
No problem.
Name and address, please.
Steve Gutierrez, 7615 Corrales Road. So first of all, I think it's useful to talk about the scale of the variance request that we made. We have 2.93 acres as shown by the 1999 survey. And we are short by 7/100 of 1 acre to produce that minimum requirement. And if we look at that, to give you a scale, it's approximately the width of this desk that my lot is narrow by. So it's 2 feet 2 inches narrow in order to accomplish the 3 acre size. So I just wanted to get a size out there of what we're talking about. So for the variance, I had sent out 18 certified letters to neighbors. None of them whom responded with any concerns. During the meeting, we had an online person provide feedback, which they supported the approval. After the meeting, I had 3 separate independent parties introduce themselves to me and offered their support for the approval of the P&Z decision. The P&Z decision meeting, P&Z unanimously approved the variance request 5-0. And I found it a bit odd that the only party that had a concern was the village questioning the decision of the village for a piece of property that had no particular village interest or public interest. It's simply a variance request that went through the P&Z. The approved variance was for 3 equally sized lots of 0.97 acres. In the letter that came to the administrator, there was the idea of producing two conforming lots and 1 non-conforming lot. But that didn't occur until after the approval of the variance was issued. So that discussion came up after the meeting of creating 2 conforming lots and 1 non-conforming lot. I learned this from Lori Stout and indicated that seemed like a reasonable idea to consider. Had the village asked me before appealing the decision, I would have agreed to that option as well. Therefore, I'd like to stipulate that I accept their alternative solution of 2 conforming lots and 1 non-conforming lot as stated in their letter. If this body were so inclined, there would be no need to proceed any further, as if we are all in agreement on this solution. Otherwise, I will proceed and I'll refute the points that were been raised in this appeal.
I would say that's very kind of you, but it's not relevant. The discussion is about the 1 acre lot size. So I would go ahead with your discussion.
Mayor, can I ask a question? So can I make a motion that we approve 2 1 acre lots and a non-conforming lot?
It's not relevant. The appeal is on the 1 acre lot size, the variance to lot size. That's
Okay.
what the appeal is about.
Yep.
But the letter that provided to this body and to me states that there is an alternative that they're willing to accept of 2 conforming lots and 1 non-conforming lot. It's in the
Mr.
letter.
Audio, are you online?
It's the last sentence of the letter.
Mayor and councilors and Mr. Gutierrez, I think that the best thing to do is get all of your evidence, Mr. Gutierrez, into the record. And then at the final decision-making point, it is within the council's authority to amend the decision of P&Z. But I think we need to hear your argument against why your proposed variance was not legal that was made by the village.
So first, I'd like to address the issue. There's 3 points that are raised in the appeal letter. And I'd like to address those 3 points that were raised in the letter. First of all 3 alternatives, which included the one in the letter of 2 non-conforming, 1 conforming, plus the alternative of purchasing of adjacent land or borrowing land, all produce exactly the same result. It's a replat of 2 lots into 3 lots. In all cases, there's no additional lands being added to the village. So the density of the village is not being changed by this proposal. It's exactly the same if whichever alternative we pursue. It's all exactly the same. So I also want to clarify some of the statements in the appeal that I have not spoken to. There's multiple neighbors on my north side, not just one neighbor to contend with. And it's an idea, but it's just, it was never pursued. It's just, they asked me, are there any other options? And I said, well, yeah, I mean, you can always try to buy land, but whether I can successfully buy the land is an entirely different question. I haven't approached that solution yet at this point. The also the concept of borrowing lands, it's my family members that have properties across the street, not me. In the letter, it states that it's I have land, and it's not me, it's my family members that have land. So my question is, why pursue a more complex solution when the simplest approach is to implement and manage? The first option of producing a small sliver of land from a willing neighbor produces an unusual L-shaped piece of property. There's existing fence lines, there's sheds. The only practical way to purchase land from a neighbor is sideways. And that would be a sliver of land that would produce an L-shaped piece of land out there with the majority of the property here and 7/100 of an acre here, which is just several feet in width. So we'd end up with an L-shaped piece of property, several feet in width on the leg of the L. The second option is to borrow against other family-owned land. Produces, I think, a bookkeeping issue for future generations of the landowners of this borrowed land. So, for example, a future party could question why are they required to pay taxes on a piece of property that they can't utilize. So that opens the door to questioning what happens when transactions occur in the future, whether it's transferred to other family members or if something happens in the future when the lands are sold. I know this has been done in the past, but I also believe those records are not consistently dealt with. The borrowing of land is done on a case-by-case basis. So rather than pursuing a solution which has produced a contorted piece of property or utilizing a concept of land borrowing, why not simply use the variance approach? That's what this was created for. I went to the P&Z, proposed the solution, supported my arguments, and asked for an exception to the standardized conditions, which was approved by the P&Z unanimously. So why not move forward with the simplest and most straightforward approach and uphold the approval of the P&Z Commission? Second, I'd like to address the question of historical ownership of the property. Many of us historical families have a long and quite interesting story, which is raised by the deed in question. My mom and dad were both raised in Corrales and have lived there their entire lives, catty-corner to the piece of property that we're talking about. On my dad's side, as we mentioned, his mother was a member of the Montoya families, which previously stated had deeds going back to the 1700s of Corrales. For the deed in question, we have to look at my mother's side. She was born in 1943. Her father was a member of the armed forces, but she never had a chance to meet him. Instead, she was raised by her grandmother and her adopted father, Louis Dubout. Her grandmother's Lena Sandoval, which has a family name long associated with this area. And Louis is also a long time and interesting history. He was born in the 1890s. He was a cook on a wagon train. And his father was Emile Allery Sr. And we know the Allery family has been here for generations. And that's the historical tie to this piece of property. Louis was the son, the fourth son of Emile Allery Sr. So as he was aging, he deeded his land to his raised daughter, my mother, here, and deeded the lands to them. And so that is how that transfer of property occurred. Just like my parents deeded their lands to me, he deeded their lands to them. And Emile, before him, deeded the lands to Louis. So these properties have been in the family line of possession for well over 100 years. Also, as a historical family, that land, that purchased land, I want to clarify the 2.5 acres to the 2.93 acres. The land was we don't know when that land was last surveyed, when it was deeded in 1966. So it's an inaccuracy of the survey that represents the difference between 2.58 and 2.93. It's not that we were given more land or that we acquired more land. It was inaccuracies of the surveys done as a historical basis in time. So once again, I still claim that as a historical family, Our lands existed well before the 1 acre rule was implemented. And it existed, these lands of tracts of land existed before the Corrales Main Canal was put into place, which did take an easement across that property. And it existed before Corrales Road was paved. Initially, it was dirt, and now it became paved and the easement became wider. And in both cases, that 2.93 acres, which is our most accurate representation of the size of the land, had been reduced over time. We know that because the easements exist on both sides of our property. So I would disagree with their statements of the 2.58 versus 2.93. That's the land never changed size. It's the accuracy of the survey that's been changed over time. And had our forefathers been aware that in the future a 1 acre rule would exist, you can be sure they would have fought for that easement and made sure that the 1 acre rule could be satisfied. But they had no foreknowledge of these things coming up in the future. And they, for the public good of the village, offered their lands and provided their lands as easements so that the Corrales Main Canal, irrigation and the pavement of the Corrales Road could occur. For the last item raised, it's in the letter. It was not raised verbally today. But as far as I can tell, it does not appear to be a point of appeal for me. It is clear the village attorney did not agree with the decision, as stated in her appeal letter presented to this body, and she made the following statement, quote, she felt the applicant had not shown hardship to not be able to further subdivide the property and was not being deprived of reasonable use of the property. So in my feeling, I don't believe a feeling is a basis for an appeal. It's a disagreement, but it's not the basis of an appeal. So it is my opinion that just because a party does not agree with the P&Z's unanimous decision to approve the variance is not the basis for an appeal. So I would disagree with that argument that I didn't meet the conditions because all 4 conditions were presented at the P&Z meeting, and it was unanimously decided 5-0 to approve those variants based on my discussions and presentation I made at that time. Further, I would maintain that it is a hardship for my family and a deprivation of reasonable use, as I have 3 children to pass the land on into the future. So this is the principal purpose for the variance request, is so that I can hand down a piece of our Corrales heritage to each one of my 3 children. And just like my parents did before them and their parents did before them, so that each of them can have a single lot for their families and for their future generation uses. So it is a deprivation of use and it's a hardship, I believe, because of a piece of property that is 2 feet, 2 inches too narrow. Let's see if there's anything else. Okay. In closing, it is my hope that I have reasonably provided arguments against all of the points raised in the appeal, and that you knew not to overrule the P&Z's unanimous decision and approve the variance request. Thank you for your attention and consideration.
Counselor Knight?
Thank you, Mayor. Thank you, Mr. Gutierrez. We got in our packet, we got an aerial shot. Are you familiar with this?
I hadn't seen it.
I did email you the packet on Friday when I emailed it to the council.
Oh, I didn't see it. Okay. I saw the letter, but I didn't know there was okay.
So my question is there's 2 houses on the lots right now.
1 house, 1 trailer.
Okay, so it says lot A and lot B.
Yes.
Where would the cutoff be for this extra lot?
We would replat them into that. They're not on they're in between the existing structures. They wouldn't interfere with existing structures, if that's your question.
So my question is, if you replotted, would there be a house on each acre?
Still.
Okay,
Plus a third then vacant lot behind the trailer.
behind the lot A that we're looking at, it seems like.
And there, up on the screen is the, one of the
Yes,
photos in question.
yes. So lot B would become smaller because it's 1 1/4 acre now.
Okay,
Lot A would then be 1 acre or let's say 1 acre in size. And the remaining 0.93 acres, or however we decide to do it, would be to the left of lot A, I guess,
okay, thank you.
up to the ditch line.
Okay, thank you.
Counselor Murray?
Thank you, Mayor. Mr. Gutierrez, I got some questions. So based on the 1966 deed and your purchase of Lot B, I didn't see any demonstration that you owned Lot A. Do you have a deed?
Yeah, sure. Yeah.
But it wasn't included in our packet, so I
Oh,
did not know if you owned that lot or not.
yeah, I mean, that we have the deed that was purchased. Lot A and no, that's Lot B. Lot A, we purchased from you in February.
Oh, yeah.
Yeah.
Well, the reason I brought that up, because when I was looking at the Sandoval County parcel map, they still had that lot in your mother and father's name.
Yeah, I'm not sure why.
Well, have you filed with?
Sure, sure, the property taxes are, well,
Well,
I got
the
it.
other point is the property taxes were by your father and mother, not by you.
Well, no, that's not. I have the property taxes. And I have the deed. I didn't know that was required.
Okay,
In there, and I have
I'm just trying to clarify who owner.
yeah,
ownership and who's
I'm the
paying
owner.
taxes on
I'm
it.
the legal owner.
All right, I'm just going to ask you, did you have the power of attorney to act in behalf of your mother and father?
Well, they signed the deed.
Okay, all right. So on line 209, Attorney Strife was discussing that she was talking about the variances and so forth. And then our PZA stout, she came back based on the differences, talking about 2.93 acres. She was a little fuzzy on her, excuse me.
Sorry.
Time's up. Yeah, time's up. Okay. But she came back with the difference, and there was no survey or plat that gave us an accurate dimensions of these two lots. And that,
Well, the
that
last
concerns me, and that was one of the things that the planning and zoning attorney was talking about. Since we did not have a current survey, we did not have accurate dimensions of those two lots. And why were we approving something that we did not have current accurate dimensions on?
The last survey was done in 1996. I suppose we could believe that technology changed enough that there could be a slight change in that difference. But I did speak to get the land surveyed after we were approved on the variance. It is the same company who did the original survey in 1996. And they were confident that the acreage was accurate. What the work they did in 1996 was accurate. But I did not proceed with that because we got the appeal. And so it made no sense to pursue any further at that time.
No, that doesn't make sense to me, because why didn't you present the survey during the Planning and Zoning Commission?
Well, I had the 1996 survey, I did.
But there was some discrepancy between the 2.93 and what PZA stout computed. I'm trying to reconcile that difference.
I don't think there was any difference, was there?
It's in the minutes. She states, I did my math based on the 1999 plat, came up with a number that is different from what he came up with by a small amount.
Oh, it's only because I rounded to 2 decimal places. She rounded to 3 decimal places.
Okay.
That was the only
But
difference.
Her comment was, if a variance is for a specific known number, we need to know what that number is. And then basically she goes on to say that the municipality has the right to set lot sizes, which is true. And just like someone were to come to us with a build a structure, they would have to meet the minimum lot acreage.
If I can ask Lori, did we have a disagreement, Lori, on the size of the lot?
Like he stated, he had said 2.94 acres. I looked at the 1990 plat and I came up with 2.93 acres. That was the difference.
Okay.
So the most recent plat in 1999 says 2.93 acres, which I believe to be more or less what's there.
Okay. So line 251. Attorney Strife.
Fair. I just want.
Excuse me, Mr.
Okay.
Excuse me, Mr. Spears. So on line 251, the Attorney Strife goes on to discuss, and she talks about the 0.07 difference, that if we allow a 0.07 difference throughout the village, it would actually increase the density of the village. And consequently, we're increasing density, the number of buildings per acre, than just one per acre. So by reserving land on the other side of Corrales Road, it has the same mathematical effect as keeping the density the same. So maybe Mr. Audio can tell me how this set aside works, because if you were to do a set aside and bring that up to the 3 acre lot size, how would that be platted over on the other side of the road, or would it?
Mr. Audio?
So, Counselor and Counselors and Mayor and Mr. Gutierrez, so in looking at it, what has happened over time is there have been particular factual circumstances come forward when someone was trying to meet this 1 acre lot size requirement. In talking to Lori, and she can weigh in on this after I speak, there's no prescribed rule. There's simply some cases where this has been done in the past, where there has been a piece of property that's closely adjacent to the lot in question to preserve that density, that has been allowed. And she has this one example that she has of that. I don't think there's anything in our written code that allows that. And there is nothing that has been otherwise written in regulations. So this has just been it occurred in a case where P&Z, and I don't know if it was appealed to governing body or not, but they had allowed that fix for this issue in the past.
Well, my question is, how does that, if it's set aside, I mean, how does that legally go against the other lot which you're pulling this additional land from?
I believe, but Lori can speak better to it. It would have to be platted as there'd have to be an actual transaction for that purchase of that piece of land. And then there's going to be a plat reflecting that.
Thank you, Randy.
Yeah. Do you want to speak?
Sure, Counselor. Again, with the example that I gave with Sandia View, there is a plat. There's an 8-plex on one piece of land. The plat has a name, lands of whatever it is, I've forgotten. And that set aside piece of land on this legal document, on this legal plat, states it specifically to bring up to the correct density for the development. It is set aside for that development, and it's not even adjacent. There's a lot in between. So there's precedent for this to happen.
When the person who owns that lot sells it, he cannot sell that portion of the lot, right?
Correct.
Okay.
It's not buildable. It says that, states that on the plat as well.
Okay, thank you. So on line 251, again, Attorney Strife is continuing the discussion. She's talking about the 1 dwelling per unit per parcel. And I guess I already talked about that, but Mr. Gutierrez, do you think the village has established lot sizes for A1 and A2 for a reason?
Well, it's not my part. I wasn't around or involved with that decision. I don't have a history on that.
Well, I'm asking for your opinion. Why do you think that we established these lot sizes for?
Well, as a guideline to keep the rural nature of the village.
Okay, do you agree with them?
Well, in my case, I don't think I changed the rural nature of with the 2 feet of size. I don't think I'm impacting the rural nature. I don't think it's visible to any of my neighbors. I don't think it impacts any of my neighbors.
Okay.
So I don't think it has an impact in our case.
On line 274, Commissioner Marshall makes a comment. Our charge, of course, is to uphold policy, but it's also to retain the cultural historic value of Corrales and these historic properties. But if you look at the entire village, in the entire village historic.
But there's very few historical families left. All the lands purchased.
I'm not talking about families who own lot. I'm talking about the village itself.
All the lands that most of the vast majority of families who own land today in Corrales purchased them knowing the conditions of the land and knew the rules of the village. Our lands were established well before that, and we didn't have any control over that. So that decision has impacted the ability of us to use our lands.
Yeah, but so, okay, so you have a parcel now, it's 2.93. It was grandfathered in at 2.93. The ordinances change now to say that the lot size is 1 net acre, 43,560 feet. Any changes means that you now have to follow in under the current ordinances.
But we haven't changed the land.
No, you may not have changed the land, but you are trying to attempt it now because you're now replatting from 2 lot sizes to 3.
on the acreage that has not changed for hundreds of
As
years.
immaterial, you've got 2.93. There's no discrepancy there. All I'm saying is you now have to follow under the rules of the village because you are now trying to change the plot or the plat of the land from 2 lots.
What I'm
to 3.
asking for is some flexibility on the on the side of the village to take into consideration that historical families have contributed to the public good and that there should be some leeway in allowing them to utilize the lands and for their use and their families.
Also on line 287, Attorney Strife is also trying to clarify about the land. This is what we are putting the cart before the horse because there is no survey other than the one that is from 1999.
Yes.
Okay, so we could assume that the acreage is correct. We shouldn't grant a variance now knowing that the acreage may be incorrect. That's because now the survey is called into question.
But we stipulated in the agreement of the variance that the final survey had to be no smaller than 2.93 whatever acres in there. And the variance was dependent on that condition that the land was no smaller than the 1999 survey results.
Well, and on top of that, let me ask you this then. Since the 1999 survey has the MRGCD or the New Mexico DOT right?
Hi, everybody. It's really baby again. I love it.
I'll restate my question. Was the MRGCD and the New Mexico DOT right of way ever adjusted since the 1999 plat?
No, those were issued in the 1930s or whenever that historically was done.
Okay, so you're asking for us to deviate from our ordinances to satisfy your requirement. Is that correct?
I'm asking for to uphold the P&Z unanimous decision, which has already approved the variance, and to address the reasons of the appeal, why that should continue to be upheld.
Okay, so let me ask you this question. This has to do with part A. The variation of this article will not be contrary to public interest. If your variance is granted, won't the public find that they too can seek variances in the village A1 density of 43,560 square feet?
I believe that you could, I believe that there is no public impact because I have all 18 neighbors who did not, who didn't provide any feedback on that. So my 18 neighbors around me approved of the process.
I'm not talking about your 18 neighbors. I'm talking about the entire village.
Again, I would say that for historical families, I think there should be some allowance on historical, as we even showed here. We had a survey that was half an acre off from the correct one. And so, you know, my 2.93 acres could have easily been done from a survey mismatch of a fence line being moved over 2 feet on either side of my neighbors that was done over 100 years ago. So there's survey errors that build up over time. And I'm saying, let's be a little bit flexible when we're talking about less than 0.1% of an acre.
Okay, let me
Talking
ask
about
Council Murray,
0.07 of an acre.
I want to move on to someone else for a second. Okay,
okay, because I was pretty close to getting B towards the end.
we'll come back. We'll let somebody else ask.
I'll use the floor.
Councilor Knight.
Thank you, Mayor. You know, we have ordinances that we need to follow, but we have a variance in there in case we need to address it in this room and this, you know, P and Z and we look at the variances. So yeah, you may say it's 1 acre. It's pretty hardcore that it's 1 acre, but there is in our ordinances that say we can look at variances. And that's what we're doing tonight is looking at a variance that to me, 3.97 acres, as the gentleman said, it's like 2.5 feet. You know, is it really going to impact, you know, everybody in the village? I don't think so.
What's your question?
That's my comment. It isn't a.
Oh, well, can we ask the questions first and then we'll have a discussion?
Okay, I guess my question is, why aren't we following our other ordinance about variances? That's my question.
Councilwoman.
Ms. Gutierrez, you indicated correctly that the vote was 5-0 with the Planning and Zoning Commission with a condition. The condition was that you get a survey. It's been 60 days since the May 15th hearing. You indicated that you spoke with the company that did the original survey. Do you have a certified letter from them that indicates that that
I have a quote from them for the survey.
a quote?
They gave me a quote to survey the land with the
And have you
three
done- have you
equal,
done- have
with
you
three
done the
equally
survey?
sized lots.
Have you done the survey?
No, we have not done the survey because once the appeal came through, Lori recommended that, hey, you need to, we don't know if this is gonna happen now or what the decision's gonna be, and I don't know to replat into 3 equal sized lots or 2 conforming lots and 1 non-conforming lot. So there was uncertainty how we were going to move forward. So I requested that we wait until the decision of this meeting so that we can then complete the survey.
Lori, could you maybe shed some light on that?
What I said was that there was an appeal period and the plat could not go forward until the appeal was heard. Not that he couldn't, he's welcome to resurvey the land. He just can't submit a plat to the Planning and Zoning Commission for consideration until the appeal is heard.
And that's the purpose of the survey, is for the replatting of the land.
Council Burkett.
Yep. Thank you, Mr. Gutierrez. Just a quick question. You had made a comment about when people buy lots in the village, they understand what they're buying and they understand the rules. Just want to clarify, you bought these 2 lots, one of them in 2000 and then one of them in February of this year?
They were, yeah, deeded to me by my parents.
Okay. Okay. I appreciate it.
Council Murray, did you have a question?
Yeah, I have a couple more. So under the variance request, what conditions are unique to the property? What does make these lots unique?
Well, I addressed that in the meeting and they're in the meeting notes of what I addressed. There were I raised those 4 points specifically. And I indicated what those 4 items were.
Attorney Strife seemed to think that that this submission was not rising to the uniqueness of the land.
I don't know, I can't say, but the P and Z approved it 5-0, so they agreed with my 4 points that I raised.
Forget the vote right now. The P and Z vote doesn't matter. We're just talking about the variance request before us. So I would abstain from any mention of the vote right now because we're working on that issue. So the part D of the variance, it says authorized for lot controls and not for use of the premise. Are you not seeking to the proposed lots for development? And isn't that the use of the premises?
Each of the lots would be, of the 3 lots would be transferred to my children. And what they do in the future is their decision of what they want to do.
But you're
with the
planning
plots.
on developing them. If they don't take the land, what do you do with the land then?
Well, they'd be transferred to them. They'll inherit the land.
And they would sell it and it would be developed.
Well, I would hope not. I would stipulate the condition that we keep that for future generations in our family. That would be my desire.
Actually, Stuart, I don't think that's relevant.
Okay,
What they want to
very
do.
good.
So,
So this comes down, my last question to you. Who owns the lot across the street on the east side of Krause Road? Is that your father and mother?
Father and mother with the stipulation that they will be deeded to my sisters when that time comes.
Okay, because I was going to ask you, why couldn't you just subdivide that lot since
That's already spoken for
Okay.
in our family.
so, all right, very good. That's my question. Thank you.
okay, thank you, Stuart. Anyone else? Okay, thank you.
And I just wanted to say the final note, that's why we went through the variance process, was to look for the exception over the 1 acre minimum rule. And I tried as best as possible to meet all those conditions during our presentation at the P and Z meeting.
Okay. Council, how would you like to do this? You want to debate in open session? You want to go in closed session?
I prefer
Oh,
open.
Lori.
Mayor, councilors, am I allowed to give a brief recap?
Sure, come on, or you want to come up here and do it? I shouldn't have made you walk up here, should I?
It's okay. That's fine. Counselors, this is so very important. By granting the variance, what the Planning and Zoning Commission did was create legislation allowing for a smaller lot size, increasing the density, the number of buildings per acre, It would be 3 lots and it will have 3 houses someday. That will happen. It will open the floodgates. And I am again going to respectfully request that you overturn that decision, because if it's not reversed, how would the council direct me in the future to proceed with future plating requests? I probably have 20 people per year who don't quite have enough land. And I have to tell them that our ordinance minimum is 1 acre, the 43,560 square feet. So what will I tell these people? That's my point.
I have a question.
Councilor Knight.
So would you see that a variant request is land specific? So, you know, somebody might come in and say, well, I have like 0.5 acres and I want a variant for that. I mean, that is a huge difference between the amount that his variant is for and a half an acre.
Then my next question would be, because our code says 1 acre, what would now be the acceptable size for a lot when someone comes in and asks me? What is the acceptable low point if it is not in fact 1 acre? There's got to be a line in the sand, and I have to tell that to applicants and
I would say 1 acre, unless you want a variant, and then you can come before P and Z and us and find out if, you know, if there's the 4 objectives that it meets.
okay. Thank you.
Oh, sure. Yes.
So I think it's exactly the purpose of the P and Z Commission to review the variance request. And based on their body of knowledge, they make the decision whether that's a reasonable request or an unreasonable request to make. So that there was also a point.
I know exactly what you're going through.
That Lori's brought up.
It'll come back around.
Yeah, I'm sorry. I was and I bet you if I sit down,
It'll come.
Yeah.
Yes, sir. Councilor Burkett.
I have one question for Administrator Curry, if I could.
Yes, sir.
Just before we have a discussion, I'm just curious, the last sentence of the letter does propose an offer of 2 1-acre conforming lots and a 0.93 non-conforming lot. In that proposal, would the assumption be that the 0.93 non-conforming lot would not be a buildable lot? Or can you explain to me what that sentence was intended to convey?
That proposal was if this body affirmed what the P and Z Commission did. If you affirmed it, then that would be our proposal. However, as was stated by Lori and myself at the beginning of the meeting, we were asking you to reverse their decision rather than affirm it.
Councilor Alsobrook.
Thank you, Mayor. So to clarify, Mr. Curry, that statement was if we uphold the planning and zoning decision so that we would not then wind up with 3 non-conforming lots.
Correct.
Thank you.
Councilor Woolman.
Yes, Mayor, I was wondering if I could get some clarity on this property across the street. I'm sorry, this property across the street, which would make up the difference between the 0.97 and the full acre. What's how does that come about? In other words, how do we add that portion to the portion across the street?
Ms. Stout.
Thank you, Mayor. Just as with the plat that exists where that happened, there would be a plat. It would show the lots, and then it would show and describe what the 0.07 acre remainder piece is a part of that plat.
And that could never be used for any other purposes.
Correct.
Because
It
it's now
would be
part of-
identified on the legal document, which is the plat, as set aside land not to be developed.
And could this body then make that a requirement, depending if we were to go ahead and overturn the Planning and Zoning Commission?
Actually, we're going to make a decision as to whether we're going to uphold planning and zoning's decision. That's our, in fact, I did have 3 different.
Can't amend.
4, maybe it's 4.
Mayor, I can help clarify.
Go ahead, Randy.
So Councilor Woolman and councilors and mayor, the option would be to affirm the decision as is, to reverse the decision and grant the appeal, or to modify the decision. So we're getting into the realm of a modification now with your question, but you can't require someone to purchase other land. They'd have to bring to you a proposal for such a condition. You can't place a condition that requires them to go purchase a piece of land that they may not be able to. They would have to bring forward that proposal in a application for variance from this rule, or through administrative approval through Lori if that was possible. But that they have not brought forward information that they are requesting to do that. So right now, all we have before us is affirm or reverse. And with this, the caveat is the administration asks for this amendment, which the applicant agreed upon. If you do affirm, then you could affirm it so that there would be two conforming lots and only one non-conforming lot. The other thing I kind of want to clear up is there's been a lot of discussion here by the applicant and other the counselors about who is making the application here. They do come from a historic family, and their family has been here for generations and had land in this area. But the key part, the only thing we can consider is what you have before you. And that was a piece of property purchased in 1966, subdivided then under county jurisdiction, that did not include the MRGCD ditch or Corrales Road, and it was then platted at 2.58 acres. It was resurveyed up to 2.93 acres. And so the historical aspect of it is not necessarily present here. If it had always been an undivided piece of land, and then there had been Corrales Road going through it, then that Corrales Road would be an easement that you do not have to exclude from the measurement of the lot. But here you have a lot with no easements in it that was platted in 1966 prior to the existence of the village. So I'd say that is the facts before you.
Thank you, Randy.
Mayor,
Hold on, I have Mr. Gutierrez is going to make a comment. Go ahead.
Okay, so 2 points. There was a concern raised about opening the floodgates. And I think there's a reasonable approach to that consideration. We're asking this because of our historical nature, that these lands were established well before the village had those 1 acre rules in place. And so I think you can easily limit this to anybody who has purchased their lands, knowing the conditions of the property. The rules of Corrales don't have that same flexibility or leeway that a historical family might present to you. And in our case, we're definitely showing this is within reasonable surveyor error that occurs over generations of time. And I think that's a reasonable presentation that would limit a floodgate of people coming to here, because there's a limited number of those cases out there. Also, the only reason these lands are deeded and changed is because they're being transferred to family members. We're not selling the land to third parties. We're moving the land from one family member to another. So over time, as is historically done, you split the lot and you send it and you give it to your children. So it's not an action that we subdivided and bought the property. It's a transfer of the family, of the land of the family from one generation to the next.
Okay. Who was that Councilor Mira? Go ahead, Councilor Mira.
yes, sir. Thank you, Mr. Mayor. 2 quick questions. I understand perfectly clear that we cannot talk about amending the issue at hand. But one question before I get to that is, if there were a non-conforming, if they were, but that's not an issue right now, could that non-conforming acre be used for building purposes, but since it's not an acre, wouldn't it not conform then to building of any sort?
Counselor Stout, Miss Stout. Sorry
Not
about
yet.
that. I
It
promoted-
would be a buildable lot under our current code. There would be a house on it ultimately. It would be a buildable lot.
Even though it's not an acre, it doesn't have to conform their rules, like set aside and everything else.
In around 2021, when the land use codes were revamped, so to speak, it made any legally platted lot a buildable lot regardless of size.
Okay, thank you for that one. And the second question is, understanding that we're not doing any amending, and that's not within our prerogative tonight, is that assuming that the owner does not get the variance requested, does that mean that this comes to an end, or can he come back to the planning and zoning? Not that we suggested it, that may or may not be an issue, but can he come back with that offer that we cannot discuss tonight because you made that offer after the fact? Could he start all over again? He may be delayed, maybe 6 months, maybe a year, but are we thwarting him from not being able to come forward with a different plan at a different time?
The alternate options, the set aside and the potential purchase of land from the owner to the north were actually discussed during the Planning and Zoning Commission, but the applicant stated he would rather have the variance instead.
Okay, thank you.
Can I make a comment?
Sure.
My name's Sam Metler.
Oh, sorry.
I've lived in Albuquerque.
What's that? No, we're not doing public comment. Go ahead, Councilor Murray.
All right, thank you. So if I understood you right, a non-conforming lot cannot be built on. Is that correct?
If it's a legally platted lot, that the changes that were made to council or to ordinance, remember we had all those half-acre lots. And our previous code basically said you couldn't build on them. And so what changed was the code now says if it's a surveyed, legally platted lot that went through some planning and zoning authority, regardless of size, so it accepted those grandfathered lots as now acceptable and buildable.
But those were grandfathered lots, though.
Correct.
Not created lots.
Absolutely.
So this would be a created new non-conforming lot, could not be built on.
Well, our code says if it's surveyed and platted and approved by a planning and zoning authority, it's a buildable lot.
Well, that's idiotic.
I agree.
Any further questions?
Thank you, Mr. Mayor, and hence my question. Yes, sir. Thank you, sir.
Okay. So what do you want to do? You have an open session or a closed session?
I would prefer open.
Agreed.
Okay, so we have a motion to continue in open session
Second.
and a second. All those in favor signify by saying aye.
Aye.
So we'll debate this in open session. Who wants to start? Councilor Alsobrook.
And thank you both, Mr. Curry and Mr. Gutierrez, for talking with us tonight, and you too, Lori. In my many years on planning and zoning councils before coming here, and then in my experience here in the village, hardship variances are due to the land, the nature of the land, not who owns it, not who resides on it, not who's going to use it and what they're going to use it for. The variance is based on the nature of the land, its shape, its slopes, any natural features that present hardships. So I don't think this meets that. For the argument about family inheritance not being an issue, if we establish that we can go substandard lots here so that you can divide this between your 3 children, Mr. Gutierrez, each of them may have 2 grandchildren. And at that point, what's to prevent them from coming to ask for a variance to split their lot into 2 because of the historical trend, the family inheritance? So that's not part of hardship. I don't see it that way. So those are really the only comments I have right now.
Okay,
Happy to hear everyone else's.
all right. Yes, sir, Councilman Burkett.
So I would, I was thinking a similar thing to Counselor Alsobrook, that I'm glad that Mr. Gutierrez did not have 4 heirs that he wanted to share the land to, because everything he said, which I find compelling, would be equally compelling with 4 kids, but the lots would have gotten smaller, and with 5 kids and with 6 kids. And so I don't think we can factor the fact, the inheritance really into it at all. I will say there was a comment that none of the neighbors have expressed concern. I've gotten emails from 2 neighbors. One said they were directly adjacent. One said they were a neighbor. I have not verified the location of either of these people, but both of them said that they were against this variance. They were against anything less than an acre in general, but they are 2 people that say they were adjacent to the property. So there is some perceived hardship by them, whether it's locally or whether it's just overall village concern of people building on less than 1 acre lots. And I agree again with Councilor Alsbrook that this doesn't seem like it creates a hardship that really requires a subjective answer. This seems like the hardship is that the lot's not very big. And there was talk over and over about surveys are historically different and there can be errors. The survey could have had an error the other direction as well. But that is something that we are not discussing. I think for the case, it's better to assume that the error was in the direction of making it smaller, but perhaps the original 2.58 acres was accurate and there was an error, a fence was moved a couple feet, and perhaps the error went the other direction. And so I also think we have to go with what the survey says, which is it's less than 3 acres, regardless of if a fence moved, because we don't know which way it moved. So my leaning would be to overturn the opinion of planning and zoning.
Councilor Woolman.
Yes, I think there's a compromise to be had here. And if, as Attorney Strife emphasized repeatedly, the question is density. And if you can include the portion across the street as part of the potentially 3 or more acres, I think that's maybe something that Mr. Gutierrez could consider if we were to vote to overturn the decision of planning and zoning. And come back to you. And could that be, can I ask questions?
Sure.
Could that be done administratively?
It would be done through plat. So the plat would be heard by the Planning and Zoning Commission, but they would be seeing 3 acres, 3 lots.
Councilor Burkett.
Can I just express an opinion on this whole set aside thing? I feel like that is worse than a variance. I feel like it's a
That's
3-card
really not
Monty.
part of our discussion.
Right.
I mean,
It keeps
I
coming
want you to have
up.
your opinion, but at the same time, it's really not relevant.
Well, amendment is one of our options. And so as an amendment, I think that that is shady versus actually just granting a variance in the light of day, finding 0.07 acres elsewhere to say that we're setting it aside. Feels like it's a 3-card Monty that we're doing for land. And I would rather just grant a variance, to be completely
Well,
honest.
we don't have a motion yet. Would anyone like to make a motion
Can I ask
To-
a question?
either grant the appeal or deny granting the requested variance? Yes,
All right.
Councilor Knight, I'm sorry.
Yeah, I have a quick question for Lori. Say if this went through,
Speak in your microphone, please.
just a hypothetical, if this went through for the 2 acres and then 1 non-conforming acre, if they platted it and that's what happened, in 20 years, when the new grandkids come along, can this be re-subdivided?
Well, but
That's really
it would
not.
depend on the code at the
concern.
time. But
Well, it is because it was brought up earlier.
Well, but we don't know that that's going to happen.
I
You're-
just want to know.
What we're doing now is addressing a variance. You know, the what ifs and what could happen, all those things, we don't have a clue. You're predicting the future.
No, I'm not. I'm asking her if this is platted
Okay.
in 10, 20 years, can it be replatted to have half acres rather than the original plat?
not under current code, but there would now be a legal argument that could be made in a court perhaps. And I don't know how that would go.
Councilor Murray.
Mayor, yes, I tend to agree that I'm against it, like Councilor Burkett, I'm against the set aside. I'm also against the two conforming lots plus the non-conforming lot. I don't like the idea of the non-conforming lot being built on, the way the ordinances are written right now. I think that Councilor Alsobrook and Councilor Burkett both made the comment that this is not a hardship. As Councilor Alsobrook says, it has to do with the nature of the land. And it's for lot control. It's not for the premises that exist on the land or anything else. So I think that I'm going to make a motion that we deny this variance request.
Do I have a second?
I don't think Councilor Murray is getting his intended language correctly.
Approve the appeal.
The governing body may grant the appeal and deny granting the requested variance.
Okay.
Is that your motion?
Yes.
Okay. Do I have a second?
I'll second that.
Okay, we have a motion and a second. Is there any further discussion or comment?
I do have one.
Okay, go ahead.
Thank you, Mr. Mayor, members. With setting my vote at the present time, I only had my question with non-conforming lot. That's a little out of it, and since we discussed it, but what bothers me the most is that an offer was made and it seems to be in writing, and that's where my question comes in. Was I wrong in assuming, because I'm hearing on the phone, was I wrong in assuming there that they said that that was done in writing? And so therefore, did we make an offer, although it may not be discussable tonight? And I could totally understand that, but was that offer in writing on behalf of someone from Corrales?
If I may, Councilor Miera and councilors, what that was a suggestion made by the administrator in his appeal. If you did not want to grant his relief that he requested, which was a reversal. If you didn't want to reverse, he said he would prefer that there only be one lot made as non-conforming and two conforming rather than have three non-conforming lots. But that's only if you don't reverse P and Z and deny the application.
Okay, Councilor Mira?
I can read this.
Looks like he's talking but muted.
Is he still there?
Oh, no.
I am here. I'm sorry. I had on mute. I just wanted to make sure that that offer was not on the table tonight. I understand that, but there are other options. Should this thing not go through tonight, there are options that the owner can take. So thank you.
Thank you, Councilor Mira. Ron, did you want to make a comment?
No, I was just offered to read it verbatim if anybody wanted it.
Okay. Anyone else? Are we ready for a vote? Councilor Murray?
Yes.
Can you review and
restate these.
restate it? what
Oh,
we're
let me,
voting on?
the motion is that the governing body is going to grant the appeal and deny granting the requested variance. Is that correct, Melanie? Okay. Councilor Murray, how do you vote?
Yes.
Councilor Burkett?
Yes.
Councilor Alsobrook?
Yes.
Councilor Knight?
No.
Councilor Woolman?
Yes.
Councilor Miera?
Yes.
Okay, 6-1, the requested
5-5.
variance is denied and the appeal is granted. That's it. Oh, I've got to do the assignment. Okay, sorry. Scratch that. Council has now made a decision. I'm going to direct our legal counsel, Randy Audio, to prepare the findings and conclusions and decision of the governing body. This document will be prepared and will be distributed to confirm the vote and will be voted on at a date that we will decide. The next council meeting is July 23rd. You think we'll have it ready by then?
Randy, can we have appeal findings ready for the council packet on Friday?
Man. Well, you
Okay,
want me to keep working tonight?
I need them by 8 a.m.
Yeah, we'll talk to Corey and I will work on those. I'll get back to you. I do not know whether we'll have them ready for
Okay.
next week or not.
the next meeting after that is August 13th.
We can definitely do that.
All right. Okay, so now our business is completed. We are adjourned.